This afternoon, the Senate Judiciary Committee held a hearing on non-citizens who have been detained in the wake of the September 11th attacks. Among those testifying, a representative of the Justice Department, the head of the American Civil Liberties Union, and a man who was detained for 2 months. Wisconsin Senator Russ Feingold chairs the 2.5-hour hearing.
Hearing will come to order, please. We, I believe, have a vote at about 2:20, 2:25, so I'll make an opening statement, and if the ranking member is here, we'll do that as well, and perhaps be able to get through the first panel, at which time I'll recess and we'll come back and begin with the second panel as soon as we possibly can. Welcome to the third of 4 hearings on DOJ oversight, preserving our freedoms while defending against terrorism. This hearing will focus on the issue of individuals detained in connection with the September 11th attack investigation. This hearing will explore the importance of the Attorney General's providing a full accounting of who is being detained and why, as well as other basic information about the status of individuals detained since September 11th. We will also consider the Department of Justice's plan to question 5,000 individuals of Arab and Muslim nationalities in connection with the investigation. The terrorists struck the heart of our nation's financial capital when they struck New York City and took the lives of thousands of Americans. In the shadow of where the World Trade Center once stood is the Statue of Liberty, standing tall and proud with a torch raised to the skies. She shines her light on a city and a nation struggling to cope with this tragedy and working to prevent any such horrific act from ever happening again. Most important, though, Lady Liberty is a reminder of why Americans and immigrants, who, like my forefathers and those of probably everyone in the room, arrived on our shores, desiring to be Americans one day. They love our nation, and they are proud to be a part of it. Her beacon at the Golden Door to America is a beacon of freedom, a beacon of hope, and a beacon of justice. I fear that America's beacon of freedom and justice is threatened as we face almost daily revelations of extraordinary steps by the Justice Department that snub the rule of law and threaten to erode fundamental constitutional rights. As my colleague Senator Kennedy eloquently stated last week, no senator and no American has a monopoly on wanting to bring the perpetrators of the September 11th attacks to justice and doing all we can to prevent future acts of terrorism and the loss of American lives. I fully support our law enforcement officials in their tireless efforts to leave no stone unturned as they strive to protect our nation from future attacks. But as we move forward in our fight against terrorism, Congress, and especially this committee, has a responsibility to ensure that the constitutional foundations of our nation are not eroded. The beacon of freedom must continue to shine on our nation. During the course of the investigation of the September 11th attacks, the Justice Department has detained over 1,100 individuals. The Justice Department recently began releasing some information about the people who have been detained on federal criminal charges or immigration violations, but we still do not have a full picture of who is being detained and why. And there are reports that detainees have been denied their fundamental rights to due process of law, including access to counsel, and have suffered serious bodily injury. We simply cannot tell if those cases are aberrations or an indication of systemic problems if the Justice Department will not release further information about those being held in custody. The Attorney General has repeatedly and strongly asserted that he is acting with constitutional restraint. But the Department of Justice has a responsibility to release sufficient information about the investigation and the detainees to allow Congress and the American people to decide whether the Department has acted appropriately and consistently with the Constitution. We will hear today from Ali Al-Maqtari, who was detained by federal officials in Tennessee for almost 2 months for a minor immigration violation that would not usually merit detention. We will also hear from his lawyer, Michael Boyle, who will discuss his experience in representing Mr. Al-Maqtari and the experience of his colleagues who are representing detainees. Following Mr. Boyle, we will hear from Mr. Goldstein, who will talk about the challenges he faced in his representation of Dr. Al-Badr Al-Hazmi, a radiology resident in San Antonio, Texas, who was detained following the September 11th attacks for nearly 2 weeks. Finally, Nadine Strassen of the American Civil Liberties Union will talk about why disclosing basic information about the status of detainees is imperative, and comment on the implications of questioning over 5,000 young men from Arab and Muslim countries. This Friday, December 7th, our nation will mark the 60th anniversary of the bombing of Pearl Harbor, a day that President Roosevelt then said would live in infamy. While our nation made great strides for mankind as a result of our victory in World War II, we also lost something of ourselves when we interned over 120,000 Japanese Americans and thousands of German and Italian Americans. We later came to regret those acts. I do not suggest that what is now going on rivals that deplorable action taken in the name of national security. But I do think we need to learn a lesson from this history to question our government when it appears to be overreaching. Such questions are not unpatriotic, and they should not be viewed as an inconvenience by the executive branch. They are a crucial tool for Congress to play in its constitutional role in protecting the great heritage of this country and the rule of law. Whenever Senator Hatch arrives, perhaps after the break, we certainly will turn to him for his opening statement. And I also want to thank the chairman and Senator Kennedy for their leadership on this issue. And I, of course, want to thank Senator Hatch for his cooperation with Senator Leahy and myself in putting this hearing together. Well, I think this gives us an opportunity then to begin the first panel. I'd ask Mr. Viet Din to join us. Our first witness this afternoon is Mr. Viet Din, the Assistant Attorney General for Office of Legal Policy. The Justice Department asked that Mr. Din be permitted to testify at this hearing to give the Department's views. He has served as Assistant Attorney General since May 31st of this year. Prior to his government service, he was a professor of law at Georgetown University Law Center. He also served as special counsel to the Senate Whitewater Committee and to Senator Domenici during the impeachment trial of President Clinton. I welcome you, sir, but I would ask that you limit your oral remarks, if you could, to 5 minutes so that we can make sure we have time to get on to the next panel in light of the problem with the vote interrupting us for some time. I appreciate your being here, and I certainly, without objection, your full written statement will be placed in the record. Mr. Din?
Thank you very much, Senator, members of the committee, and I thank you for putting the full statement on the record. Let me say first that it is not an inconvenience for me to be here, rather it is an honor, and thank you for having me here to answer the questions that the committee has and continues to have, and it is a great opportunity to answer some of these questions. Your opening statement was quite moving, and so if I may, I will enter my written statement into the record and just very briefly touch upon the theme that you started with your opening statement about the nature of liberty in America. And it's a question that has revolved in my mind since September 11th and more honestly September 12th, because September 11th was a day of numbness for me. But on September 12th, I began to ask the question that I think most Americans have started asking themselves in this period also. That is why. Why is it that these zealots are willing to give up their own lives in order to take the lives of thousands of innocent Americans and freedom-loving people around the world in that horrendous attack of September 11th? Is it because we are somehow better than the people of the world? I don't think so. Americans, look around this room. Americans are the people of the world, as you say. The inscription at the base of the Statue of Liberty, it doesn't say, it says, give me your tired, your poor, your huddled masses. It doesn't say, give me your highest SAT. It does not say, give me your best and brightest. It says, give me your lowest. Give me the ordinary people of the world, and I will promise you something special. I will promise you liberty. I will promise you freedom. And with that liberty, with that freedom, America lets the ordinary people of the world do their ordinary things, but achieve extraordinary things as Americans. And so as we go forward in responding to the threat of terrorists in the future and in responding to the attacks of September 11th, we are very mindful that we will not sacrifice these values of freedom and liberty and the institutions that safeguard this freedom. At the same time, however, America is asking us to deliver to her people a different kind of freedom, freedom from fear. For without the safety of their persons and the security of their nation, Americans will not be able to go about doing those ordinary things that make America an extraordinary nation. And as we go forward in this process since September 11th and continue to prosecute this war on terror, we have tried and we have committed to preserving this balance in order to defend freedom through law, which is the work, after all, of the Department of Justice. I will speak very briefly to 3 areas that are of interest to this committee. First, with respect to the detentions, as of last evening, there are 608 persons in federal custody on criminal or immigration charges, growing out of our investigation into the September 11th attacks. Of that total, 55 are being held on federal criminal charges. The remaining 553 are being detained on immigration-related charges. The department has charged a total of 105 persons for violation of criminal law. Some of those indictments or complaints have been filed under seal by order of court. The names and charges against all others have been publicly released. Every one of these detentions, let me assure you, is fully consistent with established constitutional and statutory authority. Each of the 608 persons detained has been charged with a violation of either immigration law or criminal law, or is the subject of a material witness warrant issued by a court. Every one of these individuals has a right of access to counsel. In criminal cases, and in case of material witnesses, of course, the person has a right to lawyer at government expense if he or she cannot afford one. Persons detained on immigration violations have a right to access to counsel, and the INS provide each person with information about available pro bono representation. Every person detained has a right to make phone calls to family members and attorneys. Under INS procedures, once taken into custody, aliens are given a copy of the detainee handbook, which details their rights and responsibilities, including their living conditions, clothing, visitation, and access to legal materials. In addition, every alien is given a comprehensive medical assessment. Detainees are informed of their right to communicate with their nation's consular or diplomatic officers, and for some countries, the INS will notify those officials that one of their nationals has been arrested or detained. Aliens are permitted access to telephones. Finally, immigration judges preside over legal proceedings involving aliens, and aliens have a right to appeal any adverse decisions, first to the Board of Immigration Appeals, and then to the federal court. Second, let me address the Justice Department's plan to conduct voluntary interviews of individuals who may have information relating to terrorist activity. On November 9th, the Attorney General directed all United States attorneys and members of the joint federal and state anti-terrorism task forces, the ATTFs, to meet with certain non-citizens in their jurisdiction. The Deputy Attorney General, Larry Thompson, issued a memorandum outlining the procedures and questions to be asked during those interviews. We seek to interview those who we believe may have information that is helpful to the investigation or to disrupting ongoing terrorist activity. The names were compiled using common sense criteria that take into account the manner in which Al-Qaeda has traditionally operated according to our intelligence sources. Thus, for example, the list includes individuals who enter the United States with a passport from a foreign country in which Al-Qaeda has operated or recruited, who enter the United States after January 1st, 2000, and who are males between the ages of 18 and 33. The President and the Attorney General continually has emphasized that our war on terrorism will be fought not just by our soldiers abroad, but also by civilians here at home. Last week, the Attorney General announced a new plan to enable our nation's guests to play a crucial part in this ongoing campaign. Non-citizens are being asked on a purely voluntary basis.
I have to ask you to conclude.
I will. Let me just describe this one particular program and I will conclude. On a purely voluntary basis, to come forward with useful and reliable information about persons who have committed or are about to commit terrorist attacks. Under this cooperators program, aliens may then be eligible to receive S visa and other immigration status adjustments in order to facilitate their stay in this country in order to help us with our continuing fight. And with that, I would love to answer any questions.
Thank you, Mr. Dinh, and of course your full statement will be placed in the record. Without objection, I will submit for the record statements from Amnesty International, the Arab American Institute, and letters from Randall Hamoud and Terry Feiertag, lawyers who represent individuals who have been detained in connection with the September 11th investigation, who have also taken issue with the Attorney General's assertion that detainees have not been denied fundamental constitutional rights. No objection, and at this point, I'm going to turn to our ranking member of the full committee, Senator Hatch, for his statement, opening statement, and then I am going to withhold questions from Mr. Dinh. I plan to question the Attorney General on Thursday about these issues, and then we will recognize the senators present here for a 5-minute round, and then hopefully after the vote proceed to the other panel. Senator Hatch.
Well, thank you, Mr. Chairman. I want to thank you for holding another Department of Justice oversight hearing, this one on the detention of aliens in connection with the September 11th attacks. I also want to thank you for acceding to the Department's request that one of their officials be permitted to testify. While there is much about which we may disagree, there should be no question that a balanced and fair examination of the Department's actions requires the presence of a departmental witness. This is the third oversight hearing this committee has held in the past week, and we have another scheduled with the Attorney General this Thursday. The topics I expect we will cover today were covered extensively last week and doubtless will be revisited yet again on Thursday. We are, of course, entitled to continue asking questions, but the legal analysis remains unassailable. As Assistant Attorney General Michael Chertoff explained last week, every person detained has been charged with a violation of either immigration law or criminal law or is being lawfully detained on a material witness warrant issued by a judge in connection with a grand jury investigation. Every one of these individuals has a right to counsel. Every person detained is able to make phone calls to family and attorneys. Nobody is being held incommunicado. To the extent the detainees are not being released on bond, it is because a judge has determined that they are likely to flee, will likely pose a danger to the community, or in the case of immigration detainees, are alleged to be deportable from the United States on the basis of criminal, including terrorist activity. To the Department of Justice's credit, it understands its obligation to treat these detainees fairly and lawfully. Mr. Chertoff acknowledged last week that, quote, it is not acceptable to have a situation where their attorney can't get in touch with a detainee, and that it is not the policy of the government to try to interfere with attorney-client communication. We want everybody to have access to their lawyers, and we want to play by the rules, unquote. I take the department at its word and expect that any problems will be promptly remedied. Mr. Chairman, not surprisingly, there is a growing concern among the public that these rapid-fire oversight hearings are aimed less at providing information and more at demonizing the administration and our Attorney General for partisan purposes. I would like to believe that all of the criticisms the administration is receiving on these issues stem from a bona fide concern for civil liberties. But sometimes I am afraid to say it appears that this administration cannot take any action, however innocuous, without being second-guessed by pundits who fancy themselves armchair directors of the FBI. For example, I'm surprised and saddened that some critics of the administration have seen fit to criticize the FBI's decision to seek voluntary interviews with individuals who have recently entered our country from countries that are known havens for terrorists. I cannot imagine a less intrusive means of investigating these crimes than to ask people if they are willing to talk voluntarily with investigators. Yet even this measured initiative has drawn, in my opinion, unwarranted criticism. The recent terrorist attacks on Israeli teenagers will, one hopes, serve as an urgent reminder of the terrorist threat we face. If more is needed, I urge you to spend, everybody here, to spend some time with last Sunday's Washington Post. This article describes in horrible detail, excruciating detail, the terrible injuries suffered by so many in the attack on the Pentagon. I cannot shake from my mind the picture of Louise Kurtz, who has undergone more than 30 operations since being horribly burned in that attack. I thought the Post did a very good job in showing the suffering of these people. Mr. Chairman, the fundamental obligation of government is to protect its citizens from such harm. It is the solemn duty of this Congress and the administration to do everything consistent with our constitutional freedoms to stop terrorists from ever again striking in this country. And as some of our witnesses will make clear, we face a real and present danger from terrorist cells in this country. With that in mind, I urge my colleagues to rethink the focus of our upcoming hearing with the Attorney General. Let's put aside any partisanship and focus on the people's business. Let us ask General Ashcroft what the American people really want to know. Are we, and I think what they want to know is, are we doing everything we can to protect ourselves from terrorists? To me, that's the big question. Are we doing everything we can to protect ourselves from terrorists? And Mr. Chairman, I have great fondness and regard for you. And I know that you'll conduct these hearings fairly, and I also know that, that it is important that we get these matters on the record, and so you are doing the country a favor. But I am really concerned that, that we get about doing what we need to do to protect this country, and worry a little bit more about that. And I know you're as worried as I am, but let's just keep doing everything we can to support those who have this tremendous burden on their shoulders, not the least of whom is our Attorney General, who we all know very, very well, and who I think is giving a tremendous effort to try and to make sure that our American public is protected. Thank you, Mr. Chairman.
I think the senator from Utah, Senator and I get along exceptionally well, considering the lack of correlation in our voting records. And I know that the senator knows very...
I'm hoping.
Keep hoping. But I can tell you that I know that the senator knows that the purpose of this hearing is not to demonize the Attorney General for partisan purposes.
I agree with that.
Nor do I believe that that is the case with our chairman or the other members of the committee who are genuinely concerned about what, at a minimum, people would have to admit are unprecedented proposals. Perhaps they're justified, but they certainly are, in most cases, unprecedented. So I just wanted to clarify that on the record. And second, with regard to the interviews of the 5,000 men proposed, even the police chiefs in places like Portland, Oregon, and Ann Arbor, Michigan, are very uncomfortable with the requests there because of their concern that it would amount to the kind of racial profiling that their departments have tried so hard to avoid. So I'd simply add those items for the record, and I'd ask the ranking member if he would like to a 5-minute round with Mr. Dinh.
Yes, if I could just ask one or two questions. The Attorney General has released the number, but not the names of those detained on immigration violations from the investigation of the September 11th attacks. Now, would you elaborate on the reasons that these names have not been released?
Yes, Senator, and thank you for the opportunity to comment on that. The Executive Office of Immigration Review has discretion under 8 U.S.C. Section 3.27 C, I believe, under that regulatory provision to close its proceedings for certain conditions under certain criteria. In these 505 cases, the Executive Office has determined to at the request of the Deputy Attorney General, to close those proceedings because of concerns about the security of the information and the privacy of the individuals involved. These are civil immigration charges, and we are very, very cognizant that where a person is of interest to the investigation arising out of the September 11th attack, we will do everything in our power in order to detain these persons and deport them if they are do not have a right in this country. But at the same time, we are cognizant not to create a blacklist of some sort that would unfairly taint them in this process in order for us to carry out our investigation. Independent of that, we have obviously strong law enforcement interests and security interests in maintaining the security of these proceedings. And so for all those reasons, we have made the determination that it would be inappropriate for us to release the names and charges with respect to these individuals.
Well, thank you. In the written statement of one of the upcoming witnesses, he states that the recent regulation providing that an alien must be charged with an immigration violation within 48 hours after commencement of detention, except in the event of an emergency or other extraordinary circumstance, allows the Attorney General to hold an alien, quote, for virtually any period of time that the jailer chooses with no recourse or explanation, unquote. First of all, do you agree or disagree with that statement? And secondly, to your knowledge, has the government relied on this exception, and what were the circumstances involved if it did?
Right. No, sir, I do not agree either with the premise or the conclusion of the statement. As you know, the rule permits the INS to make a determination within 48 hours with exceptions for exceptional circumstances. I believe those exceptional circumstances include a massive influx within a particular district, so that the determination cannot be made within that time, or the transfer of various between the officers. I believe that some exceptions has been made. I do not know the exact number and magnitude of those exceptions, but I do believe that they are the exception and not the rule, that people are charged outside of the 48 hours. But in any event, it is not an unlimited exception. It has to be within a reasonable period of time, and we interpret that to be as a matter of days. And in any event, any person under detention, for whatever reason, under United States detention, always has the right of habeas corpus to challenge that detention.
Okay, now the Attorney General recently promulgated a regulation providing for the automatic stay of an immigration judge's order releasing an alien on bond in any case in which the INS initially either opposed bond altogether or set a bond of $10,000 or more. Now, what concerns with the adjudicative process prompted this regulation?
Yes, sir. There is a very specific operational problem that the INS faced and the department faced immediately after the September 11th attacks. That is where a person is determined to have bond above $10,000 under the normal criteria of danger to the community or a flight risk while out of detention. And that person, that decision, that bond determination is reversed by an immigration judge. There is no provision, there's no ability for the INS to keep that person in detention pending appeal of that decision, except for if they are fortunate enough to do an emergency stay that is granted prior to the release, the posting of bond release of the person. This operational loophole really creates a significant problem for the department, because the person, if posting bond and release, will create, in our opinion, a danger and a threat to our society and a flight risk. We will have to go then out and reapprehend the person if the Board of Immigration Appeal determines that the bond was erroneously set by an immigration law judge. The rule was revised in order to accommodate this operational need. Let me assure you that it has been used in very limited circumstances. The automatic stay provision has only been invoked 9 times since the rule was promulgated. 4 of those times were for persons previously subject to the previous versions of the rule. That is, those persons detained under Section 236C of the INA. For the other 5 cases, 2 of the automatic stay became moot because the order of deportation became final before their appeal of the bond was effected. And for the other 3, for one reason or another, the INS dropped the automatic stay invocation and did not pursue the appeal of the bond.
Well, thank you very much.
And each of the 5, by the way, were terrorism related and were of interest to the 9/11 investigation.
Thank you.
Senator Hatch. Thank you, Mr. Dinh. The vote has started, and so the most orderly thing I can think of is we'll go over and vote and come right back and begin with the next panel.
Alrighty. this? I'm just kidding. I was going to be scrambling on them. We'll talk.
Voice of what?
Call the committee back to order. Thanks for your patience. Before we begin with panel 2, I'd just like to take a moment to say a few things in response to Mr. Dinh. First, it is my understanding that the court administrator has closed immigration proceedings at the direction of the Attorney General, not on his own accord. And without objection, I'd like to place in the record an email from the court administrator to all immigration judges that make this clear. Let me also comment briefly on the new rules mentioned by Mr. Dinh, the new ability of the INS to obtain what amounts to an automatic stay of a decision to release a detainee or set for bond for that release. Once again, the department has made itself judge and jury. Prior to this ruling, all the department had to do is file a motion for a stay and then convince the Board of Immigration Appeals that the detainee presents a flight risk or danger to the community. Those requests for stay are routinely granted, but now, as I understand it, the stay is automatic, meaning that the INS itself makes the decision without any judicial review at all. And I think this is also troubling, and I think perhaps the next panel may actually want to comment on it as well. Our first witness on this panel is Ali Al-Maqtari.